The Supreme Court of India allowed the appeal in the matter of AMOL BHAGWAN NEHUL versus the state of Maharashtra and set aside the impugned order of the High Court of Bombay. Court said that the appellant was just 25 years of age and had a lifetime ahead of him. It would be in interest of justice that he does not suffer an impending trial, and therefore the proceedings are quashed off at this stage itself. Court said that the ingredients of offence under section 376(2)(n) or 506 IPC are not established in this case. The present case falls under categories enumerated in para 102.5 and 102.7 as identified by Supreme Court in State of Haryana versus Bhajanlal case for the exercise of powers under section 482 CRPC by the High Court so as to prevent the abuse of process of law. In view of the court, this was not a case where there was a false promise to marry to begin with. A consensual relationship turning sour or partners becoming distant cannot be a ground for invoking criminal machinery of the state. Such conduct not only burdens the courts but blots identity of individual accused of such a heinous offense. Court has time and again warned against misuse of provisions and has termed it a folly to treat each breach of promise to marry as a false promise and prosecute a person for an offense under section 376 of IPC. The criminal case at Police Station Karad Taluka, District Satara was registered at behest of a complaint filed by complainant alleging that during the period 8th of June 2022 till 8th of July 2023, appellant forcibly had sexual intercourse with her on the false assurance of marriage. The complainant, who had been previously married, had obtained Khula-nama from her ex-husband and had been residing with her 4-year-old son at her parental home in Kalagaon, Kargar district since 2021. While the appellant, 23-year-old student of Bachelor of Science Agriculture at Krishna College of Agriculture, Rehtre, BK Taluka, Karad district, Satara, was residing as a tenant next door with 3 other men since 25 of May 2022. Court said that after hearing both sides in this case and after carefully considering the material on record, following attributes come to the fore. Even if the allegations in the FIR are taken as true and correct depiction of circumstances, it does not appear from the record that consent of the complainant was obtained against her will and merely on an assurance to marry. The appellant and complainant were acquainted since 8th of June 2022 and she herself admits that they interacted frequently and fell in love. Complainant engaged in a physical relationship alleging that appellant had done so without her consent. However, she not only sustained her relationship for over 12 months but continued to visit him in lodges on 2 separate occasions. Narrative of complainant does not corroborate with her conduct. The consent of the complainant as defined under section 90 IPC also cannot be said to have been obtained under a misconception of fact. There was no material to substantiate inducement or misrepresentation on part of appellant to secure consent for sexual relations without having any intention of fulfilling said promise. Investigation revealed that the Khula-nama was executed on 29th of December 2022, which complainant had obtained from her ex-husband. During this time, parties were already in a relationship and alleged incident had taken already place. It is inconceivable that complainant had engaged in a physical relationship with appellant on assurance of marriage while she was already married to someone else. Even otherwise, such promise to begin with was illegal and unenforceable qua the appellant. Court said there is no evidence of coercion or threat of injury to complainant to attract an offence under section 506 of IPC. It is improbable that there was any threat caused to the complainant by appellant when all along the relationship was cordial. It was only when appellant graduated and left for his hometown to Ahmednagar, complainant became agitated. We cannot ignore the conduct of complainant number 2 or the respondent number 2 in visiting native village of appellant without any intimation, which is also unacceptable and reflects agitated and unnerved state of mind of complainant or the respondent number 2. For the same reason, criminal prosecution against appellant is probably with an underlying motive and disgruntled state of mind. There is no reasonable possibility that complainant or any woman being married before and having a child of 4 years would continue to be deceived by appellant or maintain a prolonged association or physical relationship with an individual who has sexually assaulted and exploited her.